everyone. Thanks for joining us today. I'm Tom Schneider. I work for Comcast Technology Solutions, and in particular, I work on the DataBee product, which is a tool for doing continuous compliance monitoring, as well as a tool that helps you to organize and combine all of your cybersecurity information into a cybersecurity data fabric. And I'm joined today by Annick O'Brien, who is CybSafe's General Counsel. She has years of experience in rolling out effective behavioral change as part of compliance programs. Annick specializes in GDPR and technology law. And CybSafe is a cybersecurity platform that blends behavioral science principles, data analytics, and automation to reduce human risk. And if anyone has any questions as we're having our conversation today, please put them into the chat. And if we don't get to them during our webinar today, we'll respond to you later. Hi, Annick.
Hi, Tom. I'm delighted to be here. It's such a pleasure, and I'm really excited about our topic today.
Yeah, so we're going to talk about DORA, the Digital Operations Resilience Act of the EU. And I'd like to start off, Annick. So there's a lot of different cybersecurity frameworks and regulations already in existence. So kind of why DORA, what particular issues does DORA address, and what was the reason for it being created?
I think what's really important about DORA is to remember that DORA is about operational risk. So whilst it's not specifically concentrating on one aspect of cybersecurity or one aspect of personal data, what it's trying to do is it's trying to get organizations into a place where operationally they know what their risks are, they understand those risks, and they're working to manage, to mitigate, and in some cases to accept the risks. What's interesting about DORA is it is very specifically directed at the finance industry. And why is that important? Because we do see with compliance legislation in general that when laws start with the finance industry, an industry that is used to regulation, an industry that is used to having to modify their ways of doing business, their operational how-to in order to comply with legislation, once it starts in finance, a few years later, it moves into a more general sphere. So what we see with DORA is we see legislation that is directed at the financial industry, very wide at the financial industry, and it's about operational resilience. And when we look at DORA really in detail, what we're looking at here is the concepts of operational risk and concentration of risk. And I find this very interesting because when we think about concentration of risk, we're not asking organizations to identify all of the risks and to get rid of all of those risks that exist for their organizations, but rather, where are the risks concentrated? Where do those risks really have a negative impact for your business or the people who are customers of your business? And therefore, what type of actions should you be taking to achieve operational resilience? And this is why I think DORA is particularly interesting, but also a huge step forward in terms of compliance laws in the ICT arena.
Yeah, thanks for that. And I think it is interesting the focus within DORA on resilience. So resilience is typically defined as the ability to be under attack or have some negative event occurring, but still be able to move forward and do business. And that's a really interesting feature of the Act as well.
I find the concept of resilience quite pertinent, especially that these days, when we originally looked at laws such as GDPR, people were worried about if they had a data breach. Now everybody understands that it's when we have a data breach. So you have to build up the operational structures of your organization to be resilient, to hopefully prevent the data breach, but to bounce back as quickly as possible after it's happened and to be able to manage it as it's happening. And this is where DORA is continuing along that same thread to encourage organizations to not achieve a standard whereby they claim that there will be no issues, but rather be resilient to them, and when they happen, bounce back from them as quickly as possible.
Yeah, thanks for that. And we talked a little bit about the organizations that are subject to DORA, but could we expand on that a bit, please?
Yeah, so we're looking at the financial sector, and what's interesting is it's not limited to banks, but it's a very wide umbrella term for many, many different types of organizations who touch the financial sector. So insurance, reinsurance organizations, as well as crowdfunding. So really what we see here is anybody who's touching money, anybody who's part of that economy really is captured by DORA. So I think most organizations who have DORA on their radar know what it is that they have to be doing, but I'm sure there are still some organizations on the periphery of what we consider to be the financial industry who maybe still have quite a bit of work to do, remembering of course that DORA came into law in 2024, but will indeed become even more relevant in January 2025 when it takes effect and when organizations have to have the main pillars of DORA in their infrastructure and rolling out the compliance requirements in the organization.
And then another interesting aspect of DORA is that it includes also, it has a pretty heavy focus on third-party providers and the services that they provide. And in particular, that would cover like cloud service providers. And it's interesting that DORA extends the regulators' domain, not just to the financial entities themselves, but also to some of these third-party service providers. And indeed, some of those would even be under direct supervision by the regulatory agencies due to how heavily the financial industry depends on this.
Right. This whole concept of third-party risk has actually been a hot topic of conversation in the data security and data privacy world for a while. We've seen that there are many requirements on organizations to ensure that particular levels and thresholds are reached when it comes to security, integrity, and availability of data. And what we see is that the way that the industry is structured is that many organizations rely on third parties for their ICT infrastructure. Example, as you mentioned, for cloud, but for many other aspects of information technology, organizations as a whole rely on third parties. And what the laws are starting to do, and what we really see here with DORA, is that the organization is being told, you don't have to do this yourself, but you do have to ensure that it happens safely. So we're pushing the burden of responsibility onto the organizations that are captured by DORA to say to them, you can use third-party service providers, but you need to ensure that those service providers are handling data in a secure way and that they have the operational structures in place to be resilient and to comply with those resilience criteria. We see it earlier on in other pieces of law, such as NIST and such as the GDPR in Europe, whereby we're talking about supply chain, we're talking about third-party due diligence, risk reviews of third parties to make sure that the third parties that you're using for these very important aspects of ICT are secure, are resilient, and can hold your data in both a secure but also a private manner and comply with the legislation. I think in DORA, what we see that's very interesting is that there is a push on the institutions that are captured by DORA to ensure that these third parties have contracts in place which comply with DORA, that training is done, and that their operational ways of business is in compliance with the resilience and operational aspects that are laid down in DORA. So what we do see is, and in some ways this can be a criticism towards the way DORA is structured against smaller organizations, but we do see the burden of responsibility in ensuring that third parties are compliant on the financial institutions. So for larger institutions, this will be something they need to build into their compliance frameworks. And for smaller institutions, it is a compliance cost that they will now have to assume.
Another interesting aspect of DORA is it focuses a lot on concentration risk. And it uses that term a number of times in the language of the Act itself. And in particular, it focuses on the information and communication technology third-party risk, ICT risk. And the issues that came up in July of this year with CrowdStrike and Windows, that's really very much a demonstration of the seriousness of concentration risk at this point in time. And concentration risk in that perspective is really the not necessarily over-reliance, but the heavy reliance of an individual organization on a particular provider. And then also from like a DORA perspective, the reliance of an entire industry on a particular provider. So concentration risk comes up, it's focused on, and I think another interesting aspect in DORA is that it expands the view of compliance and what's covered under the legislation to not just individual entities, but the entire financial industry as a whole. And I think that's really significant. And I think also that whole incident with CrowdStrike and Windows in July, it kind of points to the timeliness of DORA in that it was really pretty prescient that this act came into being and that it's in the process of being rolled out at this point in time, because obviously our reliance on various vendors, heavy reliance on those is an area of risk and a threat to resilience. So it's important that organizations are prepared to understand how they would deal with some kind of an outage with one of those vendors. I was curious what you might have to add on that topic.
I think I see some similarities between what we're seeing now in terms of concentration of risk and what the financial industry saw maybe 20 years ago when there was not enough legislation or regulation around maybe investment products and how investments were made. And we did see regulation coming in to the financial industry requiring for certain types of products diversification, requiring that lower risk products diversified their risk across industries to ensure that products that dealt with pensions or that were longer term investment products weren't as susceptible to the high risk elements of the stock market. We're seeing now that this same approach is applied to information security. We're seeing the pieces of legislation saying you need to have certain safeguards in place. You need to understand where risk is concentrated and try and diversify that risk. That is a mitigating factor. So I think I do see some similarities, and I see a development of the way that risk is treated in the financial industry, from concentrating on the products to concentrating on the infrastructure as a whole, and concentrating on the industry and ensuring that the concentration of risks is not just addressed within financial products, but addressed within how the industry operates, how financial institutions operationally do their business. And this is what resilience is all about. And this is where DORA is really trying to encourage organizations to meet those compliance requirements so that the risk is not overtly concentrated in one area and we don't have a repeat of issues like we saw this summer. But I will say one great aspect of the issue that we saw in the summer with the CrowdStrike Windows affair was the way in which, and the timely way in which it was dealt with, open communications, the way that we bounced back, I think is a great testament to resilience. So it wasn't just the aspect of a problem happening, but it was how did we deal with this problem? How did we rectify it? What steps are we taking to prevent it happening again? And how did we communicate with stakeholders during this event to ensure to them that things would be put back in place and that their data was not breached in a way that was highly dangerous for them?
Yeah, that's a really great point. And I think it also brings some focus to being able to respond that way. Obviously required a fair amount of preparation and a fair amount of practice leading into that. And those are definitely things that DORA points towards, is not only having disaster recovery and incident response plans in place, but also frequent testing of those, revisions of them, making sure that in fact you really are prepared and you've got a plan that you've run through ahead of time, so that once something does happen, you're ready again to be resilient and to bounce back from it as quickly as possible.
I totally agree with that aspect. And this is what we see in NIST, which has been in existence for a lot longer than DORA, but we see these elements of detect and respond, which also are apparent in DORA. And we can see that DORA is built on some of the same principles as NIST, in that we've got the detect principle and the respond principle, which are really important in the whole resilience aspect. But we also see with the new NIST 2, we see this underlying layer of governance which goes across NIST and which is a requirement that has newly come out in the last few months. And again, we can see this in DORA. The underlying function of DORA has a requirement of governance embedded into each of the pillars that are discussed. And what it does is it's trying to ensure that the operational resilience that is outlined in DORA is not a tick the box exercise. It's not a once a year check, but indeed it's part of the risk management framework of an organization, and the underlying aspect which encourages this to be a continuous thought process for those risk managers is that governance layer.
Yeah, it's interesting stuff. So pivot a little bit here, and I'd like to talk a bit about the 5 pillars within DORA. So ICT, again, which stands for Information and Communication Technology, risk management is one. ICT-related incident reporting, digital operational resilience testing, and then the 4th being ICT third-party risk, and then finally information sharing. So one thing I found interesting when reading through DORA is the ICT risk management component of it is really what I would think of, since I'm coming more from a kind of technical IT background as opposed to a legal background. To me, it's essentially a series of cybersecurity requirements. So it deals with things like asset management, access control, vulnerability management, some of the things that we think of as kind of just your classic cybersecurity requirements as they relate to IT. And I think it's interesting that it's titled as risk management as opposed to just like control framework or something, because a lot of times the argument against compliance or against any kind of framework or regulatory requirements is that they're not going to guarantee like invulnerability, and you know, it's the common saying that compliance isn't the same thing as security, which obviously is true, but ultimately abiding with some set of controls like what's outlined in DORA or a lot of other frameworks like NIST is something to build a foundation that you can begin to secure an organization on and to reduce risk for that organization. So I think looking at it from the lens of risk reduction as opposed to some kind of hard and fast security is a healthy way to view that aspect of the legislation.
I definitely agree. I think it's very important that we look at this pillar of ICT risk management. But again, when we look at the pillar of ICT related incident reporting, if you are incident reporting, it means that you are scanning for incidents. It's that you understand what incidents are happening. If you're reporting them, there has to be a risk register somewhere where you're collating this information. It means you're forcing organizations to scan their landscapes, to understand when an incident has happened, to maybe even categorize and analyze those incidents, and to record them. If you were doing all of these things, it's very unlikely that there's only one person in the organization who's actually doing this work. Most likely, you're looking at cross-functional collaboration. You're looking at systems and processes that have been put in place to enable the people who need to scan the environments to understand what an incident looks like, when one might have happened, and who to report it to. And for those people who are reporting it, to understand what they need to report. And once we find ourselves as an organization with a list of incidents that may have happened over the last 6-9 months, we start to see trends. We start to understand vulnerabilities. We cannot but understand where we might have some heightened risks and where we might need to take some measures. So therefore, when we're looking at risk management and incident reporting, I think that these two pillars really do support each other and encourage us to work more closely together under the concepts of risk. And then finally, we have the ICT, third-party risk management. So again, we spoke about that, pushing out the compliance burden onto the third parties to ensure that they too were compliant with DORA. So we find that an organization needs to understand what's happening internally and what's happening externally when it comes to risk. So I think when we look at the pillars, we do find that even though they are defined as pillars, in a way, the concepts are weaving in and out between them so that we can ensure that risk is a top priority for the organization.
Yeah, definitely. And the aspect of the risk or of incident reporting and operational resilience testing, those really speak to, again, that kind of coordination throughout the organization. And it's a thing that involves not only technical people trying to detect and understand different security events, but also then up through the organization into your executives, like what needs to be reported to whom. And there's definitely always a legal aspect, because what information, like you spoke, has to be reported. And typically most regulations also have specific timeframes around that anymore. So those are all things that really need to be understood ahead of time so that an organization is prepared when they do have some kind of an incident, that they're ready to move forward, not only with their legal obligations, but then also it spills over too into like public relations and communication and how that's going to be managed when an incident does occur.
Right, so this comes back to the concepts of protect, detect, respond that we saw in NIST and that we see again in DORA. And this concept of responding is responding to incidents that happened and to develop security awareness and operational resilience training and policies, procedures, ways of working, as well as technological measures that ensure that we can respond to issues, but also that we can respond to threats, we can respond to trends that are happening in the organization. So the concept of respond is more than just responding to a huge data breach after it happens, but it could also be responding to trends that we see that come from the testing, that come from the security reporting.
Yeah, it's a very comprehensive approach. One of the things you had mentioned when we were doing some conversations leading up to today was that DORA is a principle-based legislation as opposed to just rules-based. And could you expand on that a little bit and kind of explain what that means?
Sure. So we are seeing a development in the way in which laws are being developed in Europe. And we saw this in the beginning with GDPR, and now we see it again with DORA. And I refer to this as a principle-based piece of legislation. We are not looking at laws that are defined as code, that are defined as requirements and tick the box exercises. You must do X and you cannot do Y, but rather you must ensure operational resilience. You must report an incident within a particular time frame. You must secure this type of data. So what we're saying to people is not you need to have a firewall, you need to do phishing, but rather you need to ensure that the information that is held in your organization, either directly by you or with the use of third parties, is held in a secure way. It's held in a way that won't be breached, and in a way that if it is breached or if there is an incident, your organization knows about the incident, can report on the incident, stops the incident, and can prevent the incident from happening again. So what we're looking at is the result. We're not identifying tick the box challenges for compliance officers, which is a code-based. What we're doing is we're looking at the principle, we're looking at the objective, the result, and we're saying you need to ensure X happens. There are both, I think this is a fantastic way of developing legislation because this puts the emphasis on an organization to achieve the objective, not to tick the box, not to do the things that are specifically required as a list in the law, but rather to ensure that the objective is achieved. The objective of DORA is operational resilience. So your objective as an organization is to achieve operational resilience, not to do specific things, but rather to make sure that operational resilience happens. Some of the requirements are outlined in the legislation, but again, the downside of principle-based pieces of legislation is that we do require more support and input from regulators, from the European Board, and from local lawmaking and courts, whereby they are saying to us, this is a good example of things you can do, this is a good example of things you should not do. And again, as with GDPR, it took a while before we got the templates required, before the standard contractual clauses were developed, before model DPIAs, data processing impact assessments, were developed. And I think we're going to have the same situation with DORA. Organizations are being told to analyze risks. Again, it's hard to analyze risks when you have a blank sheet of paper and you don't even know where to start. This is the first time that your organization might have looked at operational resilience. So we wait for the regulators to come to us with templates on what are the top risks I should be looking for, what is considered, generally speaking, a high risk for a financial institution, what are ways of mitigating risks that the regulators will consider to be acceptable. So we are waiting for a little bit more information on the how to do this. But what I like about it is it's very clear on the result, and it's very clear on the principles that we need to achieve. And organizations need to take responsibility to ensure that those principles are indeed achieved.
Yeah, thanks for that. And that principle-based approach, I think, is also significant because it helps to support the velocity with which the industry is changing right now. So I think as we move forward in time, that approach makes more and more sense because technology changes so rapidly. Threats to organizations, they evolve so quickly that just giving a hard and fast set of you must do this, you must do that isn't really a viable approach at this point in time. It makes more sense to have this principle-based approach where, again, the focus is on the outcome as opposed to just the techniques you might use to get there.
Right, and we saw this indeed with Article 32 GDPR, technical and organizational measures. And the law states that bearing in mind the state of the art and the risks to the organization. So what you have to do is, if you today are starting a business and you need to implement technical and organizational measures, you need to look at the risks that are pertinent to your business, but also look at the type of software that's available or the type of trends in hacking or encryption, whatever it might be, that are current in the market, and make your decisions for technical and organizational measures pertinent to what's available. And what this means is an organization who in 2018 implemented certain technical measures might have been appropriate in 2018, but it's now 2024. So maybe technology has developed, maybe those technological measures are no longer adequate, and therefore organizations are continuously required to look at the technical and organizational measures that they have in place. And again, we see this for DORA in relation to operational resilience and the focus on resilience specifically there, which is about looking at what's available in the market, looking at what you should be able to do at this time for the industry that you're in, and applying those technical and organizational measures to achieve that aim.
Yeah. So another thing I'd like to pivot to for a minute is you had mentioned NIST cybersecurity framework a bit already, and in the background and rationale for DORA, it's called out specifically as one of the frameworks that the EU organization putting the law together had considered. And I think the cybersecurity framework, it's added some interesting aspects, I think, into the conversation because it brought that whole focus of the different functions which were originally the identify, protect, detect, respond, and recover. In version 2, they've now added, as you pointed out, govern as a 6th function. But I think that's a really great approach to looking at cybersecurity and looking at risk management in general, because it really helps to organize what you're doing in terms of, this is something to just identify assets or information that we're working with, but then also how are we going to protect that. But when our protections aren't sufficient, or indeed in some cases there are even tactics and techniques that there may not be an open way to defend against, so then you're really pivoting on to detection at that point. How quickly and are you able to detect that something negative has occurred, and then moving on to respond and recover. How do you react to that, and then how do you get back to your regular steady state environment at the end of that? And that perspective is definitely weaved through DORA, and it's interesting to see how those other frameworks were referenced when this legislation was created.
Exactly, and one thing I like to do as we see these new compliance laws developing, it's always important to go back to the regulations that exist already and the compliance frameworks that exist in your organization already, and to look at things like the templates that exist for you, the compliance agendas that you have, the diary timings of when you do particular testing or when you do particular reporting. Not each of these regulations require us to reinvent the wheel and to create a completely new compliance framework with new requirements. When we look at DORA, we can see that risk assessments are a very important part of understanding what risks we have, where they're concentrated, and how we might manage or mitigate those risks. Risk assessments are things that we also need to do with the new AI regulation. We need to understand the risks that AI is posing on individuals based on the software that is being brought into Europe or developed within Europe. We see it in GDPR, transfer risk assessments. What risks does transferring this data outside of the EU have on individuals? Data protection impact assessments, which are risk assessments, to understand, does processing this data create a high risk to the rights and freedoms of individuals? And what can we do to manage and mitigate this risk? So what we see here is we can reuse some of the policies. When we see the similarities between NIST and the pillars that exist there, along with DORA and the columns of importance that we are highlighting there, we also see that risk assessments, timely reporting, recording of reporting is all a requirement that is both required for DORA but exists already. So we should be able to build this into our existing compliance framework within the organization. I always say compliance is not just about doing the right thing, but indeed showing that you're doing the right thing. So compliance requires us to write down and to record what it is we've done, what might have gone wrong, and how we try to mitigate, manage, and prevent that for the future. And we see that with DORA. So I think when it comes to looking at DORA and the requirements that are outlined there, organizations can look internally to their internal compliance management frameworks and reuse a lot of the information that they are already collecting, or indeed a lot of the templates can be repurposed. Sometimes we will have procurement departments who are doing tests and checks on third parties. What we do is we build into that business work stream to enable those departments to really concentrate on their existing requirements with the add-on of DORA. So we're not trying to create new business processes, we're just trying to ensure that we reuse what we can and that we only add on to existing business processes. And this will ensure that we don't create shadow IT, that we don't create bottlenecks in the organization, and that there isn't confusion. Because often when we try and overlay layers of regulation on top of other regulation, individuals and organizations feel, rightly so, that they might have done this risk assessment already. They've already tested this third party for a particular thing. So I think the most important piece of implementing DORA within your organization is to take a step back and to understand what exists already, What are the processes, procedures, policies, templates? What do you already have? And from there, build your compliance framework for DORA around the existing compliance frameworks. That way you'll get buy-in for the organization, you'll reduce the extra workload, and you will, in a faster way, meet the compliance requirements that are outlined in DORA.
Yeah, it's a great description. And I, in particular, wanted to pull out one of the comments you made of just compliance forcing you to write things down and record them. And I think there's really a lot of benefit to that, because I've done a fair amount of audit support in my career, and I know a lot of times you go and talk to a team and you ask them, are they doing such and such? And the immediate response is, oh yeah, that's all taken care of. But when you actually ask them to provide some documentation around it, it's not just that the documentation is missing, but it's when they actually try to document it, you realize they're not really doing what they think they're doing. It's not being done as thoroughly or as comprehensively as it needs to be, and it's a good effort to find those gaps and to call them out and then to be able to address them.
Completely agree. I think it's very important to write down these things. I do not believe in having a policy for a policy's sake, or that the policy should drive your organization, but the policy should be a multilateral type of directional document whereby it both reflects what you do, dictates what you should do in compliance with the organization, and has a review mechanism built in so that things can be modified and updated, not necessarily but because they were incorrect, but because the law changes, because the technological environment changes, and because the needs of the organization will modify and develop over time. So it's very important that this is a continuous process and not a once written and then we forget about it type process.
Yeah, the other thing I would add there would be, you may modify it as well, because you'll find there's something you left out when you actually begin to write something down and execute it. Typically, you're going to see some gaps that you hadn't considered before.
Right, and sometimes there is a person in the organization, in the team, who is maybe filling in those gaps, and it's not written down and nobody knows. But if that person leaves or gets sick or moves into another department, then we have a hole. So it's really important that we understand what needs to be done and who needs to do it. And in that way, we can ensure that the important things are being done.
So, Annick, I think we're almost out of time here. Was there anything else you wanted to add?
I just wanted to say, for organizations that are struggling with compliance requirements as a whole, but in particular with DORA, and feel that there might be a lot of requirements that are pushed onto them that create a new compliance burden for them, they should really look at the existing policies, procedures, templates, and compliance framework in place in the organization. A lot of what exists within DORA is a repetition of what we see with GDPR. It's foundation. It comes from the same foundation as the NIST framework and other aspects of law, such as the AI Act and anything else to do with financial regulation around diversification, around risk management and mitigation, already exist. So I think you'll find that spending a little bit of extra time looking at what exists and how it can be repurposed will save an awful lot of time in the long term. And remember also that we have until January 2025, which is really not a lot of time, but enough time to make a start.
Yeah, great. Well, I really appreciate your time today, and thanks for all your insights. It's been great talking with you.
Thank you. It's been great talking to you.